And welcome, everyone. I'm going to give it another minute for people to join us, and then we'll get started. All right, I'm going to jump on in here. Welcome, everyone, to our pre-litigation playbook training. We're going to discuss the pre-litigation process from intake all the way through settlement monitoring. And we're going to do this by looking at our newest online learning module of our Fair Play for Girls in Sports cases. So thank you all for joining. This meeting is being recorded. We'll have that uploaded to our website soon after. And then you'll all have the written materials from this training, including the PowerPoint and the online module and the link to follow along on the online module provided to your email that you use to register after the training ends. So to start us off, I'm going to let Elizabeth introduce herself.
Hello, everybody. I'm Elizabeth Kristen. I use she, her pronouns. I'm the legal director at the California Women's Law Center. I have been working on fair play for girls in sports issues for about 20 years. And I'm wishing you all a happy National Girls and Women in Sports Day.
Thank you, thank you. I am Juliana Gessiato. I'm a staff attorney here at the California Women's Law Center. I have been at CWLC for about 2.5 years, and I work with Elizabeth on our Fair Play for Girls in Sports cases. So just to start off with a little bit about the California Women's Law Center, our mission is to create a more just and equitable society by breaking down barriers and advancing the potential of women and girls through transformative litigation, policy advocacy, and education. We have 4 core issue areas, which include economic security, gender discrimination, violence against women, and women's health. As you can imagine, these are very broad issue areas that often overlap and intersect. And so we're really lucky to be able to do a lot of different work that helps girls and women throughout California and beyond. And we get to do work that we're passionate about, like our Fair Play for Girls in Sports project. And I also want to acknowledge that today is National Girls and Women in Sports Day. This movement was created by the Women's Sports Foundation. It's celebrated annually and honors the achievements of women athletes, coaches, and leaders, and celebrates the power of sports to unlock limitless potential. So I want to take a moment to discuss the benefits of athletic participation for girls. These are benefits that continue from when they play in their youth that extend through the lifetime. The girls reap significant advantages from or significant lifelong benefits, in educational performance, career achievement, and physical, social, and emotional health throughout their lifetimes just by playing sports in their youth. So female high school athletes are more likely to have higher grades and standardized test scores, fewer disciplinary issues, better attendance, a greater desire to attend higher education, and increased graduation rates when compared to their non-athlete peers. It's also well documented that female athletes are more likely than other female students to make important gains in historically male-dominated academic subjects. After high school, women who were athletes before are more likely to attend and graduate from college to participate in the workforce and earn higher wages. There was a survey of 400 female executives across 4 different countries that found a remarkable 94% of these women were athletes in their youth, and that wages for athletes are 7% higher than for non-athletes. And participating in high school sports also yields meaningful long-term benefits for women and girls' health. So, female athletes have higher levels of self efficacy, confidence, self esteem, physical competence, self worth, and body esteem. They're less likely to smoke cigarettes, use drugs, engage in high risk sexual behaviors, become pregnant, or suffer from depression while in high school. And then throughout their lifetimes, they're less likely to develop heart disease, diabetes, osteoporosis, breast cancer, Alzheimer's, and all other problems later in life. So we really like to start these trainings with this focus on why it's so important for girls to be able to equally access sports in their youth. It has benefits throughout their lifetimes. So with all of that in mind, I'm going to switch us over to our online learning module. We're really excited about this type of module that we can now create. Um, Give me 1 second here. So we create these so that attorneys who want to learn about whatever subject this module is about. For example, we have one on the rights of pregnant and parenting students. And this one here is on our pre-litigation process and these Title IX athletics and fair play cases. And so these can be used for individual online learning. We'll share the link for everyone to be able to access this module afterwards. And you'll see what a great tool it is to be able to learn about all these various different legal processes. And I want to note that while this module is about our fair play cases and we will be discussing this law, we're going to go more quickly through the substance of the law so we can really focus on the pre-litigation process and our experience bringing cases from intake through settlement monitoring without having to file a lawsuit. And I want to plug that if anyone is interested in these modules and wants to work with us to create one, that's something we're very open to. A lot of legal aid organizations, for example, like to use similar online trainings for teaching clinic volunteers those subjects online as well, so they don't constantly have to reteach in person how to handle these legal matters. So with all of that, let's begin. This would be the first page you would see if you were to do this module online. I'm going to skip through it because we already know that we're here to learn about Title IX and the Fair Play Act. And I'm going to pass it over to Elizabeth to talk about the basics of Title IX and how it relates to athletics.
Thanks, Juliana. And we're going to cover this fairly quickly. We do have another training that goes in more depth on Title IX, but we want to make sure that this webinar is accessible to folks who maybe are never going to bring a Title IX lawsuit or a Title IX matter, but are interested in the tools that we're successfully using to engage in pre-litigation resolution of these issues. But to just give you the brief overview, Title IX has been on the books since 1972. It is a very short 37-word law that basically says no person in the United States shall, on the basis of sex, be excluded from education. And these are educational programs that receive federal financial assistance. Some of these slides you will see maybe represent reality that was different maybe about a year ago because it says Title IX is enforced by the Office for Civil Rights in the Department of Education. While that is still true, it is extremely difficult to enforce Title IX through the Department of Education's Office for Civil Rights due to pretty serious cuts that have been made to that department. And so there is a private right of action. You can file a lawsuit under Title IX, and we'll talk a little bit about that. And Title IX, the statute is found there at 20 USC 1681. Title IX is obviously a very broad law. It applies to education. As I like to share, when I went to law school, there were about 50% women in my law school class. But my mom went to law school in 1972 when she was one of about 10 women in her law school class. So many of us benefited in higher education from greater access to education. Title IX covers pregnant and parenting students, as Juliana mentioned. It covers sexual harassment and assault. But for a long time, it was almost synonymous with athletics. And so the idea is that athletics is an important part of education. And if an institution receives federal funding for any part of its program, it has to provide equal access to athletics. And there's going to be some resources at the end that we'll show you, and you will have an opportunity to take a look at those, and you can get more in depth on all of these questions.
I also want to take a moment here to talk about the Loper-Bright impact. I'm sure many of you are aware that in 2024, the Supreme Court held that the Administrative Procedure Act requires courts to exercise independent judgment in deciding whether an agency has acted within its statutory authority. This overruled the Chevron doctrine that would defer to agency interpretation of a law that was ambiguous. And we want to clarify here that Title IX should not be affected by the Loper-Bright impact. First of all, because no administrative guidance was directly overturned by the Loper-Bright decision. It overruled Chevron and remanded, but it didn't overturn any specific guidance. But beyond that, Title IX is a little unique because when the Title IX regulations that we follow regarding athletics were implemented, they went through a different implementation process than what exists today. So back in 1975, Congress actually had the express opportunity to decide whether the proposed regulations properly reflected its intent in passing Title IX. So we don't really view this as deference to an agency at all. And therefore, the Title IX regulations should fall outside of the scope of Loper-Bright. So continuing, we're going to look at what Title IX requires. Like Elizabeth said, we're going to go through this quickly. If you are really interested in the subject matter, you're welcome to read through the module in detail on your own or review our prior training from last year on this issue. But first, Title IX requires equal treatment and benefits. So in this module, you'll be able to see that we can click to expand our tabs to learn about each of these Title IX requirements. So treatment and benefits means that the entire athletic program should be equitable through a gendered lens when looking at equipment and supplies, scheduling of games and practice times, travel and per diem allowances, coaching opportunities and compensation, and then provision of locker rooms, practice and competitive facilities, team rooms, and more. The provision of medical training facilities, publicity, recruiting, and fundraising. So we call this the laundry list. There's a bunch of different requirements that exist under Title IX, and we look at these throughout the pre-litigation process, the intake process, to determine if schools are providing equitable facilities and treatment and benefits for both boys and girls in their athletic programs. And then I'll pass it to Elizabeth to talk about equal participation opportunities.
Yeah, so the laundry list that Juliana was talking about was the idea that if you're playing sports, you should have equitable facilities, uniforms, equipment, coaching as your male peers. So a lot of the cases that come to us come in through a disparity that somebody has recognized in their athletic programs. They often come in as softball, baseball disparities because they're different sports, but softball players can really see quite clearly that their facilities look unequal as compared to the baseball facilities that they can also see right there on their campus. But Title IX is broader than just a facilities law. It also talks about equal participation opportunities. And this says that essentially, if a school is 50% girls and 50% boys, the athletic program should also be apportioned 50-50. There is a three-part test, and the three-part test starts with proportionality, and that's what I was just discussing, which is you look at the percentage enrollment for each gender. And Title IX does largely look at gender as a binary. I think things are evolving over time, but this law passed in 72 and litigated actually not that often over the past 50 years, really talks about male and female sports for the most part. And so they're looking at enrollment and what the percentage is there, looking at the athletic program and what the percentage is there. And if there is a discrepancy, then you have to see, for example, if girls are 50% of the enrolled students, but only 42% of the athletes, you have an 8% disparity. That's significant potentially, but you also have to look at the size of the athletic program. A very small program, 8% might not really be a lot of additional girls who could play sports, maybe one or two. But usually the cases that we see, these disparities represent really large numbers. And the test is actually, is there enough of a discrepancy when reduced to individual players that you could form an additional viable team, you could add another level. And in almost all cases, at the high school level in particular, we find that a school fails prong one. And we're going to talk a little bit more about how you look at that data, especially here in California. But Title IX is not a quota. There are two other ways a school can comply with Title IX's participation mandate. The second, prong two, says that a school can show that they have a history and continuing program expansion, practice of program expansion. So what that means is that in the 70s, Congress and the institutions that were enforcing this law were saying, well, schools might need some time. They might need to build up their women's athletic program. Let's give them time. And if they're adding sports for women and girls, they could prove that they had this history and continuing practice of program expansion. These days, it's extremely rare for an institution to be able to demonstrate a history and continuing practice of program expansion, because what we often see is that a school will add a sport for girls and then subtract a sport for girls, and that is not considered continuous program expansion. So the final way a school can show that it complies with Title IX is prong three, and that is to show that it is effectively accommodating the interests and abilities of the underrepresented sex, which in our cases is always girls. And usually schools will have to show that they have surveyed their student body, that they are essentially offering all the sports that girls want to play that are viable for their competitive region. And again, we almost never see a school that is able to comply with prong three. At the high school level, it is extremely rare for high schools to have conducted the correct kinds of surveys often enough or respond to what the interest is expressed in those surveys. I will say that we have had a lot of expansion in sports for girls in California with the addition of flag football. That has been a real game changer in California over the past couple of years. And so we're really seeing a lot of schools adding flag football, which has been a wonderful opportunity for girls in high school. So the other part of Title IX that I want to talk about is retaliation. So Title IX, like many of our civil rights laws, has an anti-retaliation mandate. And what that means is that a parent, a coach, a student who complains about Title IX violations is not supposed to be retaliated against. Unfortunately, we do often see retaliation happening. The case that is headlined here from the New York Times is a case called Jackson versus Birmingham, which was a case about a coach, a girls basketball coach in Birmingham, Alabama, who complained about conditions for his girls' team, and he lost his job. And the Supreme Court decided that, yes, a coach was protected as well. In the case that we litigated, Ollier versus Sweetwater, the parents were complaining about inequality for the softball team, and the school turned around and fired the softball coach to punish the team. That kind of class-wide retaliation is viable under Title IX, and we often pursue those claims quite vigorously, because if we are not able to make sure that people feel they can't be retaliated against, it's going to be unlikely for people to complain about Title IX violations. So what are the remedies under Title IX? What can happen if you have a Title IX violation and you prevail? Almost all of our cases have asked for injunctive relief. So what that means is that we're asking for change And we bring our cases largely as class cases and saying you need to change things for all the girls in the school. You need to improve facilities, you need to add coaches, you need to add teams. So we'll talk a little bit later about what that looks like, but we usually have multi-year settlement agreements that require change and injunctive relief. Title IX can provide for damages, and there was a recent case against San Diego State where there was a damages settlement for a college case. So it was really about athletic financial aid. It also provides for attorney's fees and costs. And so that has been important as these cases can be quite time consuming. And we have a few more resources there if you want to read more about remedies.
I'm very quickly going to go through some of the California Education Code. In California, this section here kind of mirrors Title IX in that it requires equal opportunity for both sexes for participation and use of facilities in athletic programs in schools. It's important to note that in California, the definition of sex is broad in California code. So this is more protective of gender expansive individuals. And then you can see here that a lot of the laundry list is kind of included in the California code, scheduling of games and practice time, compensation for coaches, travel arrangements, locker rooms, etc. So the code does mirror Title IX, but I will caveat that our cases we have historically brought under Title IX, under federal law, and not under California law. So we can't directly speak to the efficacy of litigating a California state law claim. California state law also includes this Athlete's Bill of Rights, which talks about fair and equitable treatment, not being discriminated against, equitable opportunity, etc. And schools are required to post both Title IX athletics mandates and this Athlete's Bill of Rights on their websites. And then finally, what I want to highlight here in the California state law is that beginning in the 2015-2016 school year, schools were required to make data available on their enrollment and their sports participation by gender. So the California Interscholastic Federation, or the CIF, is the organization that governs high school sports programs throughout California. And they require that this enrollment and participation data be reported to CIF annually for an annual census. And then the CIF makes the data available to the public. So by submitting that data to CIF, these schools are generally complying with the statutory requirement to make that data available. And this data reporting has become crucial in our investigations of schools' participation gaps. We'll talk a little bit more about that later, but it's something that's really unique to California and helps us a lot in these cases to be able to right off the bat say, you reported these numbers, and based on the data that you reported, there is a clear gap in participation numbers. And then beyond the school setting, we also litigate cases under the California Fair Play Act. Again, I'm going to go through this quickly because this was actually modeled off of Title IX. It passed in 2004 and went into effect in 2005 here in California. And it requires that local municipalities, so cities, parks and rec departments, sometimes county governments, all have to make available youth sports programs equitably for both boys and girls. So whether the city is running those programs themselves through their parks and rec departments, or they are allowing outside organizations to use their fields and facilities, they have to make sure that these opportunities are being provided equitably. And this law has been in effect throughout California for over 20 years now, but few municipalities even know about, let alone comply with the Fair Play Act. And there's a similar laundry list here under the Fair Play Act that we look through these factors, including the provision of money and supplies, equitable opportunities that has a two-prong test similar to the Title IX three-prong test, locker rooms, games and practice locations. A really big one for the Fair Play Act is the fields and facilities access and the scheduling of games and practice times, because a lot of times local governments aren't running these programs themselves. They're just the host for, little leagues, local softball leagues, to use their fields. And so we have to make sure that they're providing those fields in an equitable manner to both boys and girls. So we'll discuss this again in a minute, but as in any intake, it's really important that we go through every criteria when talking about the Fair Play Act and Title IX requirements to determine what possible legal actionable inequities exist. So with all of this wonderful background, um, we're now going to start talking about the pre-litigation process. So I'm going to go through this timeline here to give you an overview of what that process looks like. And then as we continue through the rest of this hour, we'll talk more specifically about each of these steps. So we start with intake. This involves, it's like any other case, looking at questionnaires, gathering information. You might want to go to the site in question so you can see for yourself and take photos yourself of any inequities, looking for parties who might want to join, especially if you're considering a class action, and determining what kind of matter this is. What are the possible causes of action? Then we have compliance checklists that are available through this module that kind of say what is required of a school district, for example, to comply with Title IX. Let's go through our facts that we've gathered and see if the school is out of compliance. Then we can offer informal resolution to our clients. For Title IX, for example, the client might want to just go directly to the Title IX coordinator or other school administrators before doing something more formal, like sending a demand letter or filing a lawsuit. This isn't necessary, but it is an option we like to provide to our clients. A lot of times they've already done it too. Entering into retainer agreements and co-counseling agreements. Then preparing and sending a demand letter. This is generally how we really get the ball rolling in a lot of our pre-litigation cases, alerting the opposing party of the issues we've found under the law and kind of initiating the negotiation process. And then we negotiate. So we use sample term sheets that we'll talk about in a minute here, the specific case research, possibly more formal site visits with opposing counsel to facilitate the negotiation process. And we've even done mediation at the pre-litigation process. And then finally, the end goal is a settlement agreement. Obviously, this isn't always what happens in the end. Sometimes it ends up in litigation or otherwise. But when we are lucky or skilled enough, we reach a settlement agreement. And there are some samples that we'll go through in this training as well here. We also like to note that there are administrative complaints that can be made both in California or federally, but as Elizabeth mentioned at the beginning of this training, that's not a great option in the current climate. Litigation might be necessary, but it's outside the scope of this playbook. And the last thing I would say, which I don't know is here, but we do also monitor our settlement agreements. I have additional considerations to read through here as well. I'm not going to go through these very in depth, but you might want to think about the press or media strategy as you work through this pre-litigation process. It sometimes can be effective in adding pressure or finding additional claimants. We also really consider at this youth level the plaintiffs aging out of the class. So although we aren't filing litigation quite yet, it's really important that if our only client is a senior and is going to graduate in a few years, she's not going to have standing and our leverage will really decrease with opposing counsel. There's also the issue of cheerleading for the purposes of Title IX. There's an argument both ways whether or not cheer or different types of cheer should be considered sports for the purposes of Title IX opportunities. So we just like to take into consideration when we're calculating the participation opportunity gap with and without cheer to see what those numbers might look like. And then finally, fundraising and booster clubs are a pretty tricky issue at the high school level in Title IX cases because funding, even from outside sources, should be considered when you're looking at how schools are equitably dispersing funds. But a lot of times the football team is raising tens of thousands of dollars that's only going towards football. And so you have to be very careful and thoughtful about how you approach that issue in these cases. So with this big overview in mind, we are going to now talk specifically about the information gathering stage.
And this should be familiar to any of you who've had a person call you up with a legal problem and say, hey, here's my story. Here's what happened. Here's why I think something is wrong. This happens all the time with these fair play cases. We typically hear from a parent who says, my daughter plays softball, and, I have been asking for the softball field to be improved, but they always say that, we're last in line. And meantime, the baseball field looks pristine. They have cinder block dugouts. They have a refrigerator. They have a, pristine grass and infield and all of that. So that's a really important first step in the intake. But at that point, we really need to step back and make sure that we're gathering a very comprehensive set of information, because athletics is very siloed. And so what happens is that a softball parent might know a lot about the softball field, but they might not know very much at all about where do the other girls' teams practice and play, what do uniforms look like, um, what are the participation numbers for the school. And so what we do is we really walk through the whole laundry list with our clients. And so, for example, we talk about equal treatment and benefits, and we go through every part of this. And people often know more than they think they're going to know. We say, oh, do the girls ever get to use the weight room? And then they'll be like, oh, yeah, actually, no, we did try to go to the weight room once, but the football team kicked us out. So we do go through all of the different components, equipment, scheduling, locker rooms. We almost always have key points, and you'll see in Articulate these little plus signs pop out as Juliana is demonstrating. And so they really show where we think you need to be thinking carefully about conducting these intakes. And so you should, if you're really focused on softball initially, ask all the questions about the softball field that you can think of, all of the amenities, bullpens, batting cages, press boxes, snack bars. High school sports are a little bit different than college sports, a lot different, but there are certain amenities that you're going to have even at a high school level, and you need to really look at what is the situation at that school. And some schools will say, well, our softball field looks bad, but it's actually the same as all the schools in our district. That's not the relevant comparison. You really have to look at how does softball look compared to baseball. You don't only look at those sports, you have to look at the athletic program as a whole. But because football, at least until recently, was almost completely dominated by male athletes, if the school had a football program, there was almost no way for them to offset that with better treatment of girls' sports. And so we would almost always find disparities. And even with flag football, we're still finding disparities because flag football is a newer sport. They're not getting to play on Friday night under the lights on the football stadium. And so we're still seeing inequalities there. So essentially, this is just saying, do your intake. We have samples. We talked a little bit about the CIF data. This has been a really important tool for us. It is a little bit tricky to navigate in that they collect a lot of raw data, but CIF itself does not turn it into this nice formula that we've been talking about. And so what we do every time we look at a school, we create a little Excel spreadsheet for ourselves, and then we go through and look how much of a participation gap is there. I'll also just caution that CIF data is not necessarily completely reliable, and you may find things in that data that don't make any sense. They may say girls basketball team, has 0 female players, but 45 male players. So there's sometimes data errors in there. There's sometimes sports that are completely left out. Sometimes co-ed sports, they count them all as girls or all as boys. And so you really, before you file a lawsuit, you really need to try to get as much reliable data as possible. But CIF data often gives you a window into being able to start your demand letter, begin negotiations, and use that data to say, here's what we have. You reported this data to CIF. These cases, because they involve physical facilities, it is really important to go and see the site if you possibly can. This can raise some, tricky issues. Obviously, you don't want to be sneaking onto a school campus if you're not permitted to be there. But most schools in California, after the school day is over, you are permitted to go there, especially if you're being escorted by your client. And same with park and rec facilities. These are often public parks and you can go and see them. If you're uncomfortable with an informal site visit, you can wait, and we'll talk a little bit more later about how you might be able to actually request a formal site visit with your opposing counsel after you've sent a demand letter. Don't forget publicly available information. You can submit a public record request to the school district to ask for information. We've provided a sample here. And then there was a recent case in Hawaii where a parent asked for this kind of basic information, and she was told that she was going to be charged $85,000 for them to comply with her public records request. So it's not necessarily going to be easy to get this information. And what we've learned over the years is that you can send a demand letter without perfect information. In these cases, because the violations are so consistent across school districts, even if you don't have data on something, we sometimes will say on information and belief, you know, there are more football coaches than there are for any other sport. And that often is the case. Obviously, we try to get as much on the ground information as we can, but we can't let that stop us from going forward with a demand letter. And Juliana just put in the chat the link to this article about the Hawaii parent who is going to be charged 80 some thousand dollars for her public records request. So there are barriers here. Compliance checklist, there's a number of different guides here that are really useful. Title IX is complicated on one level in that there are a lot of factors and there's some technical sports terms that you have to learn. But it's very simple on another level because you're really looking at the same kind of elements at every school. And these compliance checklists can help you assess whether you're seeing compliance. And you're really looking at the overall picture for sports for girls compared to boys. So again, in theory, a school could treat one girls' team so well that it would offset the fact that the boys' football team gets the best of everything. I have yet to see that happen in a high school case. And so what we generally find is that while there may be differences in how teams are treated, overall, girls' teams are treated worse than boys' teams.
All right, and now let's say you have done a very thorough intake and you've looked at your compliance checklist and you're going to start figuring out how to choose claimants. This is a lot like choosing potential plaintiffs because if all else fails in your pre-litigation process, you might end up in litigation, and it's great to already have your plaintiffs. So a few factors that we wanted to highlight to consider, especially because these cases involve youth athletes and girls in high school. The first one here is age as a factor. We often have our clients proceed using initials because they are minors, and I'll talk a little more about that in a minute. And as I mentioned before, we want to avoid mootness. So it's important to consider not only that your child is a minor, but that they are going to continue playing this youth sport or being involved in this high school activity throughout the process of your negotiations. There is also the consideration of a tolling agreement as you're looking towards settlement to avoid running through any statute of limitations or any mootness. We also want to consider, as with any other class case, the adequacy as a class representative. So we've had people come to us with highly individualized claims about how they were personally treated, which might be a Title IX issue, and they might have a personal individual Title IX case. But really our goal here is this injunctive class-wide relief for female student athletes. So sometimes we can discuss this directly with the client and work with them to see how adequate they are as a representative. Other times, we have to suggest that they proceed with their individualized claims separately. And then it's also important to consider if your clients are a representative of multiple sports. This isn't absolutely required because we are looking holistically at the athletics program. So one girl can represent multiple different sports and different types of female athletes. But it is helpful if your client plays three different girl sports or you have a couple clients across different sports, because then they can speak to how this treatment affects them, not just in one sport, but across the entire athletic program. When we're thinking about defendants at the high school level, usually the defendant in a case is going to be the school district in which your client attends school. But usually, when we send a demand letter, we're quite inclusive to make sure that the opposing party is on notice of this issue and that the district's attorney or the right person really gets their hands on the demand letter to reach back out to us. So we usually include the superintendent, Title IX coordinators, athletic VPs, high school principals, and then more localized to the high school athletic director and coordinator. So ultimately, you want to be dealing with the district's council, but we find that the best way to get there is making the demand quite broad. And then when we look at the Fair Play Act, it's very similar to Title IX. I will say the age of individualized clients in fair play cases is less of an issue for two reasons. First is that the girls start playing younger, so you have a broader pool to choose from of potential clients. And then also, oftentimes our clients there are actually the youth sports organization. So it might be the softball league that is not getting the same access to fields as Little League. That league is our client rather than one specific girl who plays. And then defendants in fair play cases can differ broadly from case to case. Usually, the authority to allocate park land and create maintenance schedules is delegated to a Parks and Rec department, and it's delegated from the city or the city manager. But sometimes they're playing on county land, so the defendant is actually a broader county. So, what we do here is actually include multiple different people in our demand letter again. So, usually we'll send to the director of Parks and Rec and the city manager or potentially city council. And again, we're hoping to get to the county council so we can begin negotiations. And to do that, we have a broader pool of people to send to. And then finally, I wanted to make a more specific note about representing minors and keeping names confidential. We believe it's best practice to keep minors' names out of public records to protect their privacy. When we're in the pre-litigation process, this is a little easier for us. We are under no obligation to tell the opposing party who our clients are at this phase. But as we move forward to protect the minor's privacy, we can proceed using initials. We'll often, if we do end up in court, stipulate with the opposing counsel to proceed using initials. And then we'll also, in settlement agreements, include confidentiality clauses. So we have even gone so far as to use pseudonyms in a settlement agreement and have a confidential exhibit attached that includes the client's actual names. So we do our best to protect the privacy of our youth clients. All right. And now we can talk a little bit about demand letters. We have a few samples here that you'll be able to access when you can look at this module. But here is an example of one demand letter that we sent. So again, you can click through the couple notes here. These are probably similar to other demands you've sent. We try to make it really clear to the opposing party what the legal issues are that we've identified, and how we hope they can work with us to address and come into compliance with the law on these issues. So first here, I have a note about the order of concerns. Either treatment and benefits or participation opportunities could go first. Even a retaliation claim could go first if that's maybe what your client brought to you as their main issue. We usually consider what's the stronger argument or what's most important to our client. Oftentimes, if participation opportunities is first, it's because we have the clear data, the gap is large, and it's kind of undeniable. So it'll really catch the opposing party's attention. The next note we have here is just about formatting. We want this to be something that the opposing party can quickly understand what the issues are, and it's a jumping off point for negotiations. So we actually like to use bulleted lists to make it easier to respond and work with the opposing party on what each key issue is and how we can address them.
I did mention earlier that we were going to talk about formal site visits, and this is often a first step for us. We will happily, in these cases, usually get a pretty substantive response from the other side, meaning they'll say, "We received your letter. Either we need more time to respond, or let's schedule a call and go through your concerns." And it quickly becomes clear that we need to actually be on site, looking at the locker rooms, looking, at the baseball field and the softball field. And so in almost every case, even pre-litigation, we have had really good success with going to a site visit with the opposing parties. They'll often bring some of the key decision makers or the key athletics personnel. And in almost every case, they've been incredibly cooperative and given us a lot of information as we walk the site. I will say that every now and then we've had some difficulty where either the opposing counsel doesn't want a site visit at all, fights with us about what we can do during the site visit. Like, for example, we always are taking a lot of pictures. That's almost never an issue, but every now and then it is. And we've litigated that in a litigation context, and the court said it was fine that we were allowed to take pictures. You're going to want to make sure that you label your pictures, and pretty quickly after your site visit, make sure that you have a good inventory of what you have seen. And a few tips: you should make a list ahead of time, and we have a sample list. But one thing that I'll say has happened to me time and again is that there will be some secret athletic facility for boys at the high school. And so even though you kind of feel pushy, you got to say, like, what's there, what's behind that door. And sometimes you got to just say, "Please open that door, unlock that." I can't tell you how many times I have found the secret baseball clubhouse that the opposing counsel is like, "Oh, I didn't know about that." Or, "Oh, the parents built that. Oh, that's not something that we knew was there." So you really have to be thorough. Obviously, you want to be polite and respectful, but you have to be as thorough as you possibly can be as you're going through all these facilities.
We have so many photos of bathrooms at schools because we're going behind every door. All right. And then once we feel like we've we sent the demand letter, we've begun negotiations, we've done a site visit, and we've really identified the key issues and what is most important to both our client and to the broader class of athletes to really have the school come into compliance with Title IX. The next step here is creating a term sheet. So we find, especially in Title IX cases and fair play cases, where there's this clear laundry list of what's required. It's a really good way to organize what the school needs to do by creating a bulleted term sheet. So we have samples here. And I can go through here. So these term sheets are not the end all be all. It's not a final settlement agreement. So they don't have to be super specific. So here, for example, we have conduct a yearly survey of student interest. Once we agree on this term more generally and we're turning this into a settlement agreement, then we'll probably attach an example of a survey or a template that the school will use, and we'll iron out the details of that survey process once we've agreed on the term more generally. Um, we also want to be overly inclusive in our term sheets and really broad to start the negotiation process. That way, the opposing counsel, when they're redlining or responding to each of our terms, it gives us room to really negotiate and compromise on each of these terms. So as you can see here, it's organized by participation opportunities and then treatment and benefits and this laundry list that we've been talking about. In our other terms, we include monitoring periods because it's one thing for a school to say they're going to comply with Title IX and make all of these changes, and it's another thing for the school to actually do it. So we try to include a monitoring period of a few years after settlement where we're able to get reports, usually twice a year or so, during this monitoring period so we can really track the progress the school is making and push back if they're not coming into compliance with both Title IX and our agreement. And then Elizabeth is going to talk about the entitlement to attorney's fees.
And I just wanted to add one more practice point, which is just as you would in every single case that you're working on, you really need to involve your clients quite closely in both the term sheet and the settlement agreement process, because they are really the experts on what will be practical on the ground. And they're the experts in what's the most important to them and to the female athletes. And so we've definitely had situations where we learn from our clients that, number one issue is that the bathrooms are never unlocked during basketball practice or, whatever it is. And so you have to really get to that granular level with your clients to make sure you understand, while we have these general samples, each case is very specific and individual. We do ask for attorney's fees pre-litigation. Both federal and state law provide for attorney's fees in civil rights cases like Title IX. The main caveat, I would say, a couple things. One is that there is a specific provision around expert costs under federal law that says those are not recoverable from the other side in Title IX cases. This is different than in Title VII cases. And expert costs can be, very expensive part of the case. In the pre-litigation world, we do not generally use experts at this stage. We usually save that for litigation. The other issue that comes up in attorney's fees cases, just like every time you're negotiating attorney's fees, is that school district attorneys have a very different view about what reasonable attorney hours and rates will be. And so there often are disputes around this. Our best practice is to leave attorney's fees to the very end to try to negotiate all the substantive relief for our clients first, and then to address attorney's fees. And we also endeavor to include attorney's fees for monitoring, because as Juliana mentioned, these cases can go on for 3, 5, sometimes 10 years. And it's a lot of work to be keeping an eye on these schools to make sure that they're actually implementing all of the changes that they've agreed to. And that is a lot of attorney time if it's going to be done properly. We're going to talk about settlement agreements. We have a number of different sample settlement agreements. I wish I could say that they were all the same and that they were all consistent with each other. Every school has its own issues, its own concerns, and of course, every client does as well. So while we have the same general components in every settlement agreement, you will find differences. And so there are samples to look at both for high school Title IX cases and for Fair Play and Community Sports Act cases. There's an excerpt of a settlement agreement below, and this is showing that one thing that we've done to make sure that Title IX is actually part of their compliance is the idea of Title IX consultants. And this has come around in a number of different ways. So there have been third-party consultants that the school district will simply hire to ensure that they comply with Title IX. That's been one kind of model that we've used. We've also used a model where some internal school employee becomes the Title IX expert and really develops the skills and ability to monitor. And then we've been the experts. We've been the ones who have had to be really looking at every single attachment, every single spreadsheet, and make sure that there was compliance. I will just say that learn from our mistakes, make sure that you're as specific as possible when you're talking about the kind of monitoring and reporting that you're expecting from the school. We had an agreement that we thought was very clear, that we thought we were going to be getting reports, but the school decided that they were just going to be sharing conclusions and efforts, which they interpreted to be extremely minimal. And so we had a lot of back and forth with that school, and we thought that this was something we probably could have fixed had we known about it when we were drafting the agreement. There will be some issues around the dates because you're dealing with public entities. You may have signatures on one date, but the school board hasn't actually approved it until a later date. So you want to be looking for that and making sure that if you need something to happen right away, that you are timing it from whatever date you need, signature or approval date. Again, we include attorney's fees, and we try to include monitoring fees as much as possible. We ask for data collection, especially in our park and rec cases, and this has been surprisingly difficult to get cities and counties to agree to. We assume that they know they have to comply with the Fair Play Act, and it would be very difficult for them to show compliance unless they're surveying kids in their communities to know what sports they want to play. And so we've been asking them to collect that data and make sure that they're being responsive. And so that's something that we've included as well. And again, in monitoring, we're looking at the number of reports, when do they come in, will we have site visits during the monitoring period, and the like. So the settlement agreements are often quite detailed.
Great. So congratulations, you did it. You reached a settlement agreement and now you're monitoring the opposing party for their compliance. I'm not going to go through this super specifically because Elizabeth did just explain the different types of monitoring consultants that we've worked with. What I think I'm going to echo is that it's really important that the agreement is clear about what's included in the monitoring reports and then the process for our input and response. So if there's a third party consultant, are they going to be reviewing the report first and then plaintiff's counsel gets it, or vice versa? How can we make sure that our clients' concerns are taken into consideration as the consultant is reviewing for compliance? I also left a tab here that if anyone else has dealt with monitoring and has some secret new idea for us to consider, I would love to hear it. Um, and then we also include some sample settlement deadline calendars. Like Elizabeth mentioned, sometimes there are multiple dates depending on when there was signature, when does the agreement actually become effective. So ensuring that we're staying on top of the calendar is really important. And these cases can fly by, your clients, especially in high school. Maybe the monitoring period's 4 years. Well, your clients have graduated and they're well into college. So it's really important that we stay on top of ensuring compliance. So we have examples here of both monitoring reports and our responses to those reports. Other monitoring considerations include those site visits, whether or not you can view if the school, for example, agreed to update their softball field and they're making a ton of renovations. It could be important for us to go view those upgrades as they happen. Getting monitoring fees, if we can include this, we do, like Elizabeth mentioned. And then we also have had to extend agreements in the past. So we have examples there as well. And we only have a few minutes left, so I'm going to race through, but this is pretty standard for everyone closing the case. You want to make sure you close them out properly when the monitoring period ends. Your firm or organization probably has a standard letter, but we did include an example here in case anyone wants to see that. So finally, thank you all for taking this training module with us. Like I said, you'll be able to access this online for free. And then we have some frequently asked questions here, and then also this big resource bank of additional materials. So this concludes our training here. Thank you all for joining. If you're interested in either our fair play work or in these online training modules, please do reach out to us. And in the last 2 minutes, I'll leave it open in case anyone has any questions. You should be able to access either the chat or Q&A.
And Juliana, do you want to just read our two FAQs in case people might have those questions, but be shy about asking them?
That's a great idea. So our first one is, must the client exhaust administrative remedies, which is sometimes the case with other rights of action, but that is not required in Title IX cases. So while the client could try to go through the administrative process, like we mentioned, we're not currently recommending that, and it's not required in these cases. And then the second FAQ is, if Title IX claims require discriminatory intent or disparate impact. and they're kind of this unique part of the law where they actually, discriminatory motive is kind of implied because girls and boys sports are separate. So there is necessarily discrimination and disparate treatment. So we're really just looking at if the treatment of girls and boys sports are equitable.
And then the only other thing I would add that people ask sometimes is how long is the statute of limitations for a Title IX claim? There is some dispute about this, but in general, it's established that it follows state law, civil tort claims. And so in California, generally, this is seen to be a 2-year statute of limitations. It's not usually an issue in our cases because we have students who are experiencing ongoing violations. But just so you know, that is something to think about. And on the administrative remedies, some schools do have Title IX complaint procedures. We've had parents go through those. We've followed it all the way to the California Department of Education. And again, I can't say those have been particularly effective, but some people may ask you about those as well.
All right, well, it looks like we have one question about handling Booster Club equitable distribution issues. I don't know if you want to talk about that, Elizabeth.
Yes, what we've done in Booster Club cases is try to figure out what our clients think would work at the school. And so the money that comes in from Booster Clubs has to be spent in an equitable manner. It doesn't have to be the exact same amount of money. Uniforms can cost a different amount for different teams, but you want to make sure that there is an equitable benefit. And so some things that we've done have been to have that all the teams raise a certain amount of money for themselves, but then a certain percentage will go into a general fund for athletics. We've had there be schools that don't have any booster clubs that say no more. We're going to all just fundraise for all athletics. So there's a variety of issues, but of course it's very sensitive because this is an area where especially some sports have raised a lot of money historically and have had the best opportunities for fundraising. So it is a tricky issue, but we have had some successful models for that.
All right, well, it's just past 1, so thanks again to everyone who joined, and keep an eye out in your inboxes for the additional materials. Bye.